Now, Lou.
Yes, sir.
I want to put you on the spot here before we start.
Oh, my God.
You've read all these crazy cases from our Supreme Court, right?
I have, sir.
Are you able to discern any type of common denominator among the attorneys who get them caught up in these sex messes that ultimately wind up before our Supreme Court for disciplinary reasons?
No, what I've found, folks, is that they're all...
Can I stop for a second?
Sure.
My tendency is to say this could happen to any of you, but I don't know that that's necessarily true. Right. In the sense that some of this stuff is so over the top, you'd say that only like a crazy person would get involved in something like this, although there is a lot of stuff that also goes on that really could happen to any of us in here, either innocently or non-innocently. So in a sense, it's kind of a cautionary tale here. But what are your thoughts about this, Louis?
What we've been able to ascertain is there really is no rule. I mean, are there serial philanderers out there who are preying upon clients? Yes. Okay, so they're in a category kind of themselves. Are there people that just kind of, life's going along fine and they just go into this total obsession with another person? Absolutely yes, and you're going to see that too. And then I guess there are others that you could say are predators, and we're going to see one or two of them as well in the course of the day. So it's kind of all over the place, pretty much as I can see.
I just want to give you guys a couple of preliminary thoughts about all this. Number one, always be mindful that the driving force here is the human... you have to wait outside. We're going to talk about sex. You're way too young to be in here, Alan. The driving force behind this is the human sexual drive, I guess, for want of a better term. I don't know that there's anything stronger in terms of motivating human behavior and human motivation. There may be, but I'm not aware of it. This is, of course, something that's utterly necessary for human beings to continue to survive. It goes back to caveman days before they had formalized marriage to kind of bond people together. So, as long as there's going to be human beings around, human beings, be they lawyers, doctors, or anything else, are going to be attracted to each other, which means you're going to be attracted to colleagues or to judges or to clients and things of that nature, and there's nothing wrong with that. You just got to be kind of careful about how you handle yourself. That's number one. Number two, a lot of this stuff is really crazy and over the top, and you'll say to yourself, I could never get involved with something like that. That would never happen to me. And that's probably true because you're not psychotic. But don't lose sight of the fact that, again, I want these in certain sense to be cautionary tales. Anybody can have an accusation thrown at him, all right? And it may be something that is completely innocent, that was misinterpreted. It may be that in a moment of weakness you did something or said something that was inappropriate. Anybody can get himself jammed up in some of the messes that happen here, and you kind of have to think about that as you go along. But my main purpose in doing this today is to kind of sensitize you to the defenses that you can raise when a colleague comes into you who's gotten himself in a sex-related mess, and you've got to go put a defense together for this individual, either in the criminal context or in the disciplinary context, okay? So with that said, let's go forward and take a look at some of these materials. Following your lesson plan, it just kind of parallels the PowerPoint. Talk to God. I mean, that's... I couldn't find a decent picture of Snooki to put on here.
It's nice to see stuff finding the voice of reason.
I told you having women here would be a good idea. All right, here we go. Now, for those of you who do not do disciplinary law, let me just give you a couple of guidelines. A lot of what we're going to be talking about tonight have parallel criminal proceedings associated with them. So typically you'll have a situation where the attorney has been charged criminally with some type of sex offense, and it could be a petty DP, or crime. And there'll be a parallel proceeding going on through the Office of Attorney Ethics. The point I'm trying to make here is that normally when you have parallel proceedings going on, the disciplinary matter is kind of stayed. Nothing happens on that, and they wait until the criminal part of the case is over before proceeding on the discipline. The key thing I want everybody to understand is that many times the criminal case is dispositive of the disciplinary case, because if you are convicted of a criminal offense, either pleading guilty or being found guilty after a trial, that constitutes conclusive proof of the RPC violation. You are collaterally estopped under New Jersey law from raising any defense at that point. Once you've been convicted, the only issue in the disciplinary case becomes factors in mitigation of any discipline you're going to receive. So you can slug it out with respect to aggravating and mitigating factors, but you can't challenge the facts of the case. They are conclusively established by virtue of the conviction that occurred in whatever level court that you're in. By the way, I'll tell you parenthetically, the same thing applies in instances where there's reciprocal discipline. Let's say that you're a New York attorney, for sake of argument, and you're disciplined in New York, and now New York has sent the case over here so that New Jersey can reciprocally discipline you. You're again collaterally stopped from challenging the facts that led to your discipline in New York. Those are deemed to be proved. All you can basically argue are the aggravating and mitigating factors. Now, the Witherspoon case here that you'll see cited on the bottom is the latest pronouncement by our Supreme Court on sexual misconduct by attorneys. And you'll see when we get into the case that the disposition of this matter came about from a very, very sharply divided court, with two of the justices wanting to create a rule of black letter law that attorneys involved in sexual misconduct be disbarred. Very, very similar to what you see in the In re Wilson rule, where an attorney who would knowingly take money from his trust account belonging to a client without the client's permission gets disbarred in every case. And there were two attorneys, two justices in our Supreme Court that thought that that would be a good idea. The other justices were not convinced of that and took a much more moderated view. But the Supreme Court, in the opinion, Justice Helen's writing for the court, kind of restated what the purpose of attorney discipline is. And it's important you understand this because you're going to see this kind of echoing through all the cases we're going to be talking about tonight. She wrote on behalf of the court, the essential purpose of our system of attorney discipline is to protect the public, not to punish the attorney. So the punishment component of any case dealing with, a criminal violation, that's in the province of the criminal law. The disciplinary system has nothing to do with punishment. The only purpose of the disciplinary procedure is to protect the public, maintain the public's confidence in the bar, and to deter the specific attorney and other attorneys from engaging in this type of conduct in the future. The purpose of disciplinary proceeding, as distinguished from a criminal prosecution, is not so much to punish a wrongdoer as it is to protect the public from an untrustworthy lawyer. The principal reason for discipline is to preserve public confidence in the public and the integrity and trustworthiness of lawyers in general. Now keep that in mind. You're going to see how this plays itself out through the case law. Now, this Gallo case, this was a Bergen County case. Do you know about this case, Joey?
Only a few hundred feet from.
Do you remember the facts of the case or anything like that?
I do.
Talk about it a little bit because I want to kind of get into Gallo a second because it's important from a procedural standpoint, but also from a substantive standpoint.
Room represent Mr. Gallo. Okay. Mr. Gallo was a relatively young attorney who had primarily a family law practice, and obviously probably half your clients may be male and half may be female. In dealing with the female clients, while the record is not clear exactly what happened, at a very least, he admitted to touching them inappropriately. He admitted when he pled guilty to the indictment against them, and this happened in 3 different counties, in 2 different courthouses, and in his own offices. He admitted to touching 2 of his female clients on the breast against their will, simply for the purposes of his sexual gratification. And others he touched elsewhere, one in her groin area and another elsewhere on her body. And he pled guilty to 4 counts of criminal sexual contact. He was originally charged with sexual assault, which is an extraordinarily more serious offense, mandating a prison sentence, mandating parole supervision for life. That means the rest of your life you're on parole. So that had serious consequences. But the Bergen County Prosecutor's Office, right here in this county, ultimately pled it down to 4 different counts of criminal sexual contact. Now, the Gallo case, the facts are disturbing in that while they're not laid out in the case law, in the case that we have here, for this reason. As Bob told you a minute ago, if you are convicted of a criminal offense, that's the end of it. They don't need to prove the case against you because a criminal conviction equals an admission that these facts occurred, and then it's just really a question for the discipline. However, Gallo case was different because he pled to 4 criminal sexual contacts. That is, I touched her breast, I touched her groin, whatever it may be. And the Supreme Court said, even though that admission says that he is guilty of an ethical violation, it would be unfair to him, that's the way they phrased it, unfair to him to simply judge this case on those admissions. We don't have any of the facts. We don't know. We only have what he said in the criminal court. You know, did you touch her on the breast? Yes. Was it for the purpose of your sexual gratification? Yes. Did she consent? No. Okay, that tells you nothing about what had happened. And they suspected that the facts were actually much worse than that.
I have a different take on this slightly from you, and I don't know any. I'm just reading between the lines here. In sexual criminal cases, there's a Supreme Court case called State versus Smullen, which stands for the proposition that people who are giving a factual basis to a criminal charge involving a sexual misconduct really can give a much more abbreviated factual basis because of the shame and humiliation they generally feel, and it's difficult to get them to admit to these facts. So I think using Smullen, he walked into court and gave the absolute bare bones minimum he could give to establish a factual basis in Bergen County Superior Court. But I'm just wondering if that was done purposefully so he wouldn't be leaving a big trail for the Office of Attorney Ethics to have a lot of information about him. In other words, this was purposeful to prevent them from having information that they could use against him later on in the disciplinary proceedings.